Okay, good afternoon. I would like to welcome you to the Enforcement Committee session of the Medical Board of California. Today is July 28, 2016, and the time is 13:25, I believe. I'm Dr. Felix Yip, Chair of the committee. I would like to ask all of us to please turn our cell phones to silent. And for the board members, please make sure that are off the table so we can avoid the feedback noise. You may notice board members accessing the laptops during the meeting. They are using the laptop solely to access the board meetings material that are in electronic format. This is an official business meeting of the Medical Board of California, and as such, disruption of the board's business will not be tolerated. We have a designated time on the agenda for public comment, and we will be asking for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I also ask the person to conduct himself or herself in such a manner that permits the board to transact the business. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand or come forward and you'll be recognized. I would like to request all speakers complete a presenter slip so I can call you by name at the appropriate time, and the record of this meeting can be full and complete. However, this is voluntary. Please give the speaker slips to Ms. Toof. Ms. Toof, can you identify yourself for the audience? Thank you. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. For those members of the public participating via the telephone conference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press star 1. You will hear a tone indicating you are in queue for comment. If you change your mind and do not want to make a comment, please press the pound sign. Please remember to mute the volume on your screen to avoid the feedback. Assistance available throughout the teleconference meeting. To request a specialist, please press star 0. Each person will be limited to 3 minutes per agenda items. However, during agenda item 2, for public comments on items not on the agenda, the board has limited the public comment period for individuals on the teleconference and those present here today for 20 minutes. Therefore, after 20 minutes, no further comment will be accepted. During public comment on any other agenda item, 10 minutes will be allowed for comments from individuals on the teleconference line and those in the audience. After 10 minutes, no further comment will be accepted. Staff from the board's business service office will be assisting me with receiving the public comments via telephone conference during this meeting. I want to remind all speakers to please stay on topic and keep your comment to 3 minutes or less. I would like to call this meeting to order and have Ms. To please call the roll.
Dr. Yip?
Here.
Dr. Bolot?
Here.
Dr. Kraus?
Present.
Thank you.
Thank you. We're quorum, and would like to remind the member that we will be taking a roll call vote on all action items. And also for the public, after today, we should have more public members on our committee. Moving to agenda item 2, public comment on items not on the agenda. I have the following speaker slips, and Tay Morse. Mr. Morse.
Yes.
Sorry, I have to find out if you're a gentleman that said Mr. Morse.
It's okay. Can you hear me? Okay, good. My name is Ty Moss. I am here on behalf of the Consumers Union Safe Patient Project, a nationwide campaign that is organizing patient safety advocates from across California as a safe patient network. The Medical Board Executive Director has assigned the Enforcement Committee to look into amending the Medical Board disciplinary guidelines regarding to patient disclosure of probation status. We urge the committee to recommend that the board disciplinary guidelines be amended to require that physicians on probation for serious issues inform their patients of their probationary status. Unfortunately, many California patients unknowingly receive health services from physicians who have been placed on probation for a range of offenses, including substance abuse, sexual misconduct, violence, patient deaths, incompetence, gross negligence, and repeated negligent acts. When the medical board allows the physicians to continue practicing medicine while on probation, the physicians should notify their patients so they can be aware of any practice limitations and can decide for themselves whether or not they want to entrust their care to that physician. Medical board guidelines require that physicians to notify the hospitals where they have privileges and their medical malpractice insurers. Certainly, patients also have the right to know when their physicians have been seriously sanctioned by the medical board. According to published research and the medical board's own data, physicians on probation are much more likely to require further discipline than physicians who've never been disciplined. We also recommend that patient notification requirements for physicians who are ordered on probations more than one time. We recommend that the medical board demonstrate its commitment to patient safety by amending its disciplinary guidelines to require, as a standard condition, physicians whose probation is associated with certain serious violations and practice restrictions be required to disclose their probationary and practice restrictions to their patients. In addition, to help people understand why physicians have been placed on probation, to fulfill the medical board's principle that all consumers should know the history of probationary actions, the medical board should develop a standard one-paragraph, plain language summary that the probation ordered. The summary should cover the cause of the probation, including the accusations to
Please
those
conclude.
which the physician stipulate, the length of the probation, and all practices restrictions placed on the physician. The summary should include, in the first section of the decision and order of probation, in plain view of the physician's Breeze profile and website.
Mr. Moss,
Yes.
please conclude.
I will do. On the medical, we also ask that the medical board should also amend the disciplinary guidelines to wit the patient notification and optional conditions on all probation cases. This notification should include the log that we have just recommended. The medical board should develop an effective process to ensure the enforcement of the disclosed requirements. Thank you.
Thank you. I only have one speaker lip, no more, okay. Are there any comments on the phone?
Greg, do we have any comments on the line?
We have no questions in queue at this time.
Okay, thank you. So we move on, next agenda item.
Move approval of the minutes?
Second.
Okay, great. Are there any public comments from those in the audience? Any comments from those on the phone?
Do we have any comments on the line?
We have no comments from the phone lines.
Thanks. Ms. Tu, please call the roll.
Dr. Bolat?
Yes, approve.
Okay. Dr. Kraus?
Aye.
And Dr. Yip?
Yes,
Thank you.
minutes approved. We now move on agenda item 7. Ms. Delp will provide an enforcement pool update. Ms. Delp is our Chief of Enforcement.
Good afternoon. So the board has tentatively scheduled its next 2 expert reviewer training events. The training events are scheduled to be held on October 8th at UC San Francisco and on November 5th at UC Los Angeles. A save-the-date announcement was already mailed to all existing experts within the program, and staff is working with the board's Information Services branch to develop an online registration feature that will make it easier to handle this part of setting up the training. The agenda for the training will stay the same, focusing on the expert program's mission and expectations, legal considerations when opining on a case, a rundown of different case scenarios, and segments on testifying provided by an administrative law judge, a deputy attorney general, and a defense counsel. But the training will now also include a segment providing an overview of the board's central complaint unit's handling of the complaint process. And also the summer newsletter has an article about the training, which was conducted in March, so the board hopes this article will also help spark interest to entice physicians and surgeons to attend the training sessions. Training with the Office of Administrative Hearing will resume this fall, and training will be held in September, October, and November. The judges will be educated on emergency room procedures, comorbid patients, and fitness for duty evaluations. At the conclusion of the November training, the board will have provided 6 training sessions to the Office of Administrative Hearings, fulfilling its strategic objective to provide training to the administrative law judges. In 2017, a needs assessment will be conducted to determine what other topics of interest the judges may be interested in receiving training, and based on that assessment, further training may be developed. The Central Complaint Unit has decreased the average number of days to process a complaint from 162 days to 146 days. Staff has been working very hard to reduce this time frame by working overtime. Management in the Central Complaint Unit continues to evaluate the way business is conducted to find ways to streamline the process. By identifying more ways to be efficient, the processing time frame will continue to decrease. At a future meeting, Enforcement Program Manager Paulette Romero will provide the committee with a presentation on the Central Complaint Unit's complaint handling process. The Complaint Investigation Office continues to be able to maintain a caseload of approximately 55 cases per each non-sworn investigator. Management is also evaluating the timeframes it takes for CIO to process its workloads and may make some changes, including shifting some less complex duties to support staff, which will permit the investigators to focus on interviewing witnesses and subjects, initiating subpoenas to obtain medical records, and report writing. The Attorney General's office continues to report that the work product produced by CIO is excellent, and I personally want to say thank you to staff for their outstanding efforts. In the probation unit, management continues to review office policies and procedures to ensure optimal efficiency of this unit. With the changes being made in the unit, I also want to publicly say how much I appreciate staff's supportive attitude to the changes. As we all know, change is often a difficult adjustment. We're working diligently as a team, and improvements are paying off as the unit has increased the number of cease practice orders and petitions to revoke probation cases being transmitted to the Attorney General's office during fiscal year 15-16 compared to 14-15. Later during this committee meeting, I also provide a presentation regarding the timeframe objectives for staff to take action on violations of probation. With the exception of the Complaint Investigation Office, there are 6 vacant positions within the various sections of the enforcement program. Efforts to fill the vacancies continue. Some interviews have been conducted and others have been scheduled, and tentative job offers have been made pending the results of background clearances. It is anticipated vacancies will be filled by no later than September 30th, and the vacancies have not created any significant adverse impact to the workloads. That concludes my enforcement update.
Any question, comments from the members? Any public comments from those in the audience? Any comments from those on the phone?
Do we have any comments on the line?
We have no comments from the phone lines.
Thank you. Move to agenda item 5. Ms. Robinson will now provide an update on the demographic study.
Good afternoon, Chair and members. I provided an update on the demographic study at the January Enforcement Committee meeting. It was reported that the next step would be for the California Research Bureau to finalize the research design and methodology, then provide this information to Dr. Kraus for review and approval as approved by the board when requesting this report. I did not provide a verbal update at the May meeting, but a written update was provided in the enforcement program summary. It stated that on April 18th, Dr. Kraus and also Dr. Baker with the Black American Political Association of California and the Golden State Medical Society received the research plan for review. It was further stated that once Dr. Kraus approved the plan, it is expected to take approximately 2 months for the analysis and an additional 2 months to finalize the report. Dr. Kraus has approved the plan, and the plan is near completion. As a reminder, the California Research Bureau provides nonpartisan research services to the governor and his staff, to both houses of the legislature, and to other elected state officials free of charge. So the board has not incurred any costs to conduct this study. Executive Director Kimberly Kirkmeyer and I met with Patrick 2 weeks ago to discuss his progress. Patrick is a senior policy analyst at the California Research Bureau who has conducted the study. From that meeting, it is Kim and I's expectation that Patrick will be ready to present this study findings at our October board meeting. This concludes my update on the demographic study.
Thank you, Mrs. Robinson. Dr. Kraus, any comment? Since you're in,
No, I think this is a vitally important study. Thank you. I think this is a vitally important study. And I'm hoping that upon receipt of their report, there will also be able to develop some mechanisms for ongoing analysis on a prospective basis. Because unless we remain on guard to any potential prejudice in the board actions, we can never guarantee that there won't be any. Thank you for your work on this.
Yeah, you're welcome.
so we should see something in October, right?
Yep.
Thank you.
Thanks.
Any public comments from those in the audience? Any comments from those on the phones?
Do we have any comments on the line?
Yes, we do. We turn to the line of Dr. Anthony Jackson. Please go ahead. Your line is open.
Yeah, hi. Hello, Medical Board of California, Dr. Jackson. I apologize. I couldn't be there. Hello?
Hello, we're listening.
Yeah, Ms. Robinson, first of all, I want to thank you and Executive Director, Ms. Kimberly Kirschmeyer, for proceeding with this very, very important study. And I just want to let you all know how much we appreciate your guidance and your moving forward with this important agenda. I apologize. I had hoped to be there in person, but I missed my flight. So, but anyway, again, I thank the medical board and everybody, and please keep us updated on this very, very important study. Thank you.
Thanks. So now move on. Agenda item 6, Ms. Delp will now provide a presentation on the expert review program's recruitment plan.
Hello again. Okay, so I'm going to do a brief presentation on the expert reviewer recruitment plan that the analyst and myself in the program have put together. So first going to start with what is our current recruitment efforts. And what it exists of is we put an announcement in our medical board newsletter. In every newsletter, we put a standard recruitment verbiage, and it includes the medical specialties that the board is actively looking to recruit. So you probably have seen, oh, that's the end of my presentation. No, I'm just kidding. What'd I do? Okay, there you go. Making sure everybody's awake. So, you've probably seen this in the newsletter, that we just put the medical specialties that we are needing further assistance in the newsletter, and it's just been our standard language. Other areas where we recruit is just by the use of our medical website, medical expert website, and there's 4 locations where you would find information about the expert reviewer program, but finding that information is not as easy. You have to either go up to the search engine up here and actually type in the expert reviewer program. You also have, under the licensee tab, Then you also then need to click further into that area, and you need to go click on like the physician and surgeon link, and then at the bottom of that page, you'll find information about the expert reviewer program. You can also go to the About Us tab, and then you go to the Careers tab, and link underneath that, and then you also have to go further to find out information about the program. And then lastly, you can search through the alphabetical search link and type in Expert Reviewer Program. So the problem with that is you can see the layout that the information is embedded, and it's just not easily for people to find information to become an expert. And lastly, our other recruitment efforts are through our board's medical consultants and our current experts. You know, they both encourage colleagues to become experts. And as you can see, not much activity nor exciting ways to entice the physicians and surgeons to join the program is currently how we utilize that information. So we put together this recruitment plan, and we hope that by doing that, we can bring more individuals into the program, and our plan consists of 3 stages. So in stage 1, which we hope to complete by fall of 2016, we've added a new link to the home page, and that's already completed. So now when you go to the the homepage of the medical board website, there's actually this nice picture, and it has a slogan on it, and you can click on that, and it'll take you right to the expert reviewer page. So it's just right on the front page of the web. We've also added the graphic and the tagline, and our goal is to change the graphic and the pictures maybe biannually to just keep it fresh and keep it exciting and not just keep using the same picture over. We've also enhanced the licensee tab. Now it goes directly into the expert reviewer program information, and we're also going to begin to track some analytics. We'll be able to embed into these links where people are actually searching for this information and to see what value and benefit we get from making these improvements. Okay. My notes. Also, we're going to enhance our newsletter. We're going to continue to advertise as we normally do on a quarterly basis, but we'll enhance the announcement by including quotes from current experts that speak as to why he or she became an expert, their experiences, and the benefits about being in the program. And then our goal, again, is to help entice more physicians and surgeons hearing directly from their peers that they'll be more inclined to participate. We're also going to possibly include some photos of these experts and then some catching quotes as to why they are participating in the program. We're also going to solicit current experts to write articles for our newsletter, talking about their experiences and maybe to gain some more participation. And then again, even on the links on the net, there'll be some embedded links into our newsletter that we can track some analytics as to how people are finding the information. And then lastly, in our first stage, we're going to get an invitation letter drafted hopefully by the board president. And this letter will encourage participation into the program, talking about the benefits and the importance of the program. And our plan is to send this letter to department heads at medical schools to recruit faculty to become experts. And the letter also, we hope to be sent out with our license renewal applications when people meet the qualifications and they want to reapply for their medical license. We also are going to create a brochure, and this is just a sample, so it's not finalized yet. This document will provide important highlights about the program to include the roles of the experts, requirements to become an expert, and the compensation information. The goal is to use this brochure at recruitment conferences. We'll mail them to physician surgeons that also have renewed their board license, and we'll ask specialty associations to distribute it to their members. So then stage 2, which we hope to complete by spring of 2017, we're going to enhance our medical board newsletter. And this is a sample of an old but fun approach to recruit experts. It was something that was done actually 21 years ago in 1995, and it's taking an applicable a quote, and turning it into a marketing advertisement. So we're going to be brainstorming and trying to come up with some new ways to entice people to join. So if anybody has any quotes they'd like us to turn into some great advertisement, we're looking for help with that. Also, we're going to be researching external newsletters and magazines with medical specialties associations, specialty boards, and seeing if we can put like an advertisement, just a simple, just a little ad about the program. And of course, we're going to have to, explore the cost associated with this, but that's our intention also, is to just do some spot ads. And then staff will begin to attend hospital staff meetings, board CME activities, and special conferences. And there at those presentations, they'll be giving out materials like the brochure that we're going to draft, and also the president's letter to those that attend. And then stage 3 of our recruitment plan we complete in the fall of 2017 is to add to our website, our medical board web page, is to create some short snippet, like 1 to 3 videos. The videos are going to be like a little small public service announcement encouraging participation into the program. So we would like to have perhaps like the board president, our executive officer, Kim Kirchmeier, myself, some current experts, maybe our investigators and some deputy attorney general, just kind of getting a little snippet of a video and interchanging that periodically throughout too, just to keep it fresh. So that's pretty much what's it. If any comments or suggestions?
Thanks, Chief. I know that the committee, the division, has been working to put one day in October, one in November. UCLA, UC San Francisco, and also USC in Los Angeles also agreed to work on some days in the spring to help recruit experts, particularly from the faculty. They have more than 1,000 faculty that can send out invitation. So thanks for effort. Any comment from the members? Are there any public comments from those in the audience?
Do we have any comments on the line?
Yes, we do. We turn to the line of Genevieve Clairwell. Please go ahead. Your line is open.
Yes, on the recruitment project, it seemed very well done, and I'm very excited that you're going to do that. I think it might open some road to good recruitment and retention. And one aspect I think we need to be added also is civility, how we impact also the recruitment and so on. So thank you for doing that. That's all I have to say.
Thank you.
Thank you.
Okay, we'll move on to agenda item 7. Mr. Chris and Ms. Nichols from the Health Quality Investigation Unit will provide a program update on vertical enforcement.
We will be providing an update on the division's Health Quality Investigations Unit. At the last meeting, we reported that we've been conducting expeditious hiring panels throughout the state and had made improvements to streamline the background process and make it more efficient. However, it is difficult to overcome the amount of time needed to hire sworn peace officers due to the psychological screening and medical portion of this process. Once that is completed, if the candidate needs an academy, it can take another 6 months before they can assist with the caseload. Currently, we have 27 investigator vacancies, a 35% vacancy rate, and we have 14 investigator candidates in background for the investigator positions. Decreased staffing affects timelines for case completion. With the vacancies, caseloads have risen for the existing investigators. In many areas of the state, the caseloads are at 40-plus cases per investigator. Because of this, we have taken proactive, strong mitigating steps to deal with the increased workload. Effective July 1st, 2016, all new Board of Psychology and Osteopathic Medical Board cases will be investigated by the Investigation and Enforcement Unit of the Division of Investigation. They will continue to receive cases from these 2 allied health boards on a temporary basis until HQIU staffing levels return to normal. In addition, 61 existing cases from these boards were transferred to IEU from HQIU to help alleviate the rising caseloads. We are also hiring 8 limited-term, non-sworn special investigator positions that will be housed at the San Bernardino field office. These positions can be hired without the delays of background and academy process and can provide immediate relief for working the lower priority cases. These positions are not permanent, but a good placeholder to obtain some immediate relief to complete cases while the sworn candidates are in background. We plan to conduct interviews mid-August to select candidates for these positions. Additionally, we are also hiring 2 limited-term special investigator assistant positions in the Sacramento and Pleasant Hill field offices. This pilot program, if successful, will give us the ability to gather the necessary data to justify budget change proposals for new funding to permanently fill these important positions. As you know, pay has been a significant factor causing investigators to leave the agency. As we reported in the past 2 meetings, retention pay was pending the collective bargaining process. The new contract ratified by Bargaining Unit 7 members in late June 2016 includes a provision that transfers the decision-making authority to issue retention pay to the department and to CalHR. Based on this new provision, we aggressively put forward a retention pay proposal for HQIU investigators to CalHR and will work with CalHR through this process. We will update the board with any developments on this vital issue. In February 2016, staff participated in a survey regarding vertical enforcement. One of the areas identified as needing modification was the subject interview phase of the investigation. We've been working with the Attorney General's office and DCA executive staff to make improvements in this area, and we will continue collaborative efforts to streamline the process. We are currently working on another joint training session with the Attorney General's office regarding subject interviews. Our last joint training, which took place in May of 2016 regarding 805 investigations, was very successful, and we look forward to building on this success with another valuable joint training session to be held later this year. Our investigators have persevered with the challenges of an increased caseload due to current vacancies. I commend all of our staff for the hard work and dedication they give every day to protect consumers, and I am confident that these solutions we have shared today will help HQIU and maintain our ability to perform core functions while staff progress through the background process. Thank you.
Thank you.
Any questions? Yes.
Thank you for working extra hard and overtime for us.
You bet.
Do you presently have candidates training in Academy that will be available soon, or?
Yes, we do. I can let Kathleen answer that.
We have one candidate that's currently in the academy, and then we have another candidate that's been hired, and she'll start an academy in October. They start at different times throughout the year.
And some of the 14 people that we have in background are actually have academies in their previous law enforcement experience. So some of those will be able to come on board right away.
Mm-hmm. I know all too often you might not look forward to these meetings because we look at the graphs going up and we place blame on you. But we're not looking to assign blame, we're looking to help you solve the problem. Are there any suggestions you can offer to us in terms of better ways that we can advocate for you or for increased pay for investigators?
I think you have, and we've done a lot of work with the DCA executive staff, with the board, and I think some of that message came through loud and clear in the collective bargaining process, and that actually, I think some of those comments that we've made and the support that has been given, regarding this issue has actually, surfaced in the collective bargaining issue, and the contract has been updated. So, that was a roadblock that I think that we've gotten beyond, and so I'm very optimistic, and look forward to hopefully reporting good news on this issue. But I appreciate everything that's been done so far. The board's been supportive. Board staff has been supportive. The department's been supportive, and I think we're taking aggressive steps to get beyond this problem. We're working with the Attorney General's office to streamline, and I think we're on the road to better days.
Thank you.
Thank you. Just a follow-up question to these graphs again, the 365 and the 550. Based upon your best estimates as a director and looking at your new plans and hiring FTE, when we hear about this in October, do you have a goal, an internal goal that we're going to decrease by some percent? What are you thinking?
Well, I think to answer that, the increased vacancies do, affect the timelines. And so we are in a spot now where there's new staff that are coming on board. It's going to take some time to get those people trained. I hope to report that the timelines will improve or at least stabilize by the next meeting. We will definitely have more staff on board. But I think it's going to probably take a little time beyond that to start seeing the decreases, because I think we've made some progress, and we've got the ship steered in the right direction, but it's going to take some hard work to get those new people trained, to redistribute some of those caseloads, and to start seeing the graphs go in the other direction. I'm optimistic, but they will do so, and I think we're on our way to solving the vacancy issues.
I also wanted to add that part with the increased caseloads and decreased staff, we've really been focusing on prioritization and focusing on those cases that are the most egregious to protect the public. As a result of our significant efforts in that regard, some of the lower priority cases are aging a lot more. So sometimes in those graphs are hidden some of the lower priority cases. And I'd like to point out that we have made very significant improvements in the important area of ISOs, the interim suspension orders. There were 14 in the year 2014-15. There were 36 ISOs for year 15-16, which was over 100% improvement. And there was also a decrease in the length of time to obtain an ISO by 150 days. So we continue to prioritize and focus our effort and time on the most egregious cases. So sometimes that impacts the aging graphs.
One more comment, and I think you said that really beautifully, and I'm almost wondering if what you're saying could be depicted, because what you're doing at the front end is triaging, and when we would see that these are the most egregious cases that were coming down or something, so that you would almost sort it out in a little bit different than just an aggregate. That might be a nice visual to show us. Thank
We'll
you.
check into the capability Breeze has to run those different reports, definitely.
Thank you.
We appreciate your effort, for sure. Thank you. Thank you. Are there any public comments from those in the audience? Any comments from those on the phone?
Do we have any comments on the line?
Thank you. Ladies and gentlemen, for their questions, please press star one. Not at this time.
We have no
No?
comments on the line.
Okay, great. Let's move on to agenda item 8. Ms. Castro, for Attorney General's Office regarding health quality enforcement section, will provide program update on vertical enforcement.
Good afternoon. As always, it's an honor to address you. In the past 3 fiscal years, since the time that the HQIU unit was set up in DCA, HQE staff in the Attorney General's office has vertically enforced on average about 1,500 investigations per year through our lead prosecutors and primary DAGs assigned to the office where the investigation is based. Our 40 HQE DAGs spend an average of 6 hours at $170 an hour, or just $1,200 a case per investigation worked in per fiscal year. In important legal tasks such as subpoena review, subject interview participation, expert review, case disposition review, and ongoing advice and consultation. In the selected cases that necessitate a personal appearance at a physician interview, our directs travel to the district office to service that case. Most legal direction from our staff comes from email communication and telephone conversations with investigators. And from time to time, travel is required by our staff to enforce subpoenas in civil court or attend criminal bail hearings. Throughout this entire direction provided in the investigation, the focus at the investigation stage is on the case at hand and the patients who trusted you, the medical board, with their complaint. The focus is on achieving public protection and in securing the best evidence to evaluate the patient care rendered. Our 10 lead prosecutors serve as in-house legal resources to medical consultants and investigators on all cases located in the office that they serve. Our lead prosecutors travel to these offices weekly and interact with investigative staff and monitor and account for all investigations in that office. The lead prosecutors identify statutes of limitation, conflicts, and triage high-priority cases. They work hard to manage a very large investigative caseload along with their own litigation caseload back at the office, which can include federal cases as well as training and advice to investigators. Our lead prosecutors take on assignments of petitions for mental examination, preservation of cease practice orders, and reacting in quick order to enjoin physicians from hurting patients, such as in the interim suspension orders. They act as resources to DAGs assigned to investigations in that office. During this whole time, the Attorney General's legal staff directs investigations assigned to them. They manage a full litigation caseload that is in all stages of filing, settlement, hearing, post-hearing, writs, appeals, along with a long list of other legal tasks that may include appearing at reinstatement and probation termination hearings, statement of issues, citation and fine, and lawsuits, sometimes defending board members. Our DAGs work very long and hard hours. Their work week is not a 40-hour work week. They have to work as long as the time that it takes to complete the job. Health Quality Enforcement section at the Attorney General's office, we bill you by the hour and tell you what work we performed and the narratives attached to those bills. We do not receive a cost-neutral yearly amount from you. In other words, we don't get a lump sum to spend as we see fit. Every fiscal year, we return any unexpended legal service funds to you, the medical board. Of HQE's total legal services fund, investigations comprise about 20% of our total legal billings to you. In the last 3 fiscal years, the cost of the VE program in investigations for Attorney General services has been an average about $2.5 million per fiscal year. And that means an average of about 6 hours per investigation per fiscal year is what we spend working on your cases in a very judicious manner. This small investment has paid dividends in public protection, both in administrative disciplinary actions in which we file very strong accusations, obtain surrenders, revocations, interim suspension orders. We enforce your subpoenas when doctors don't want to give us medical records, and we create thoughtful settlements that rehabilitate and correct physicians and achieve public protection and public safety. My legal staff also identify physicians whose completed investigations should not be referred to our office for prosecution, and per outside independent expert review are safe to practice. The almost non-existent numbers of dismissals after hearing or withdrawals of filed accusations reflect the quality of investigations under the vertical enforcement program. Vertical enforcement protects good physicians by removing them from the cloud of suspicion in the investigation and also eliminating any unfounded accusations against them, such as withdrawals and dismissals. The in-house medical consultants play a major and key role in investigations by managing the lion's share of subject interviews. These are the interviews of physicians. It's a face-to-face contact, doctor to doctor, peer to peer. These medical consultants question the quality of care case and also identify the physicians who do not need to be remediated after a full medical consultant review. Often, medical consultants are the ones that recommend sending out cases for independent expert review, and our Attorney General staff is involved in identifying cases that might merit a citation and fine or a pre-accusation PLR, which is short of filing an accusation but sometimes addresses the issue. Educational letters are also sent out with medical consultant help. The vertical enforcement program has increased the quality of evidence reviewed by medical consultants and your retained independent experts. Namely, our participation in those physician interviews can take the form of submitted questions to the investigator or, as necessary, physical presence in physician interviews. This ensures, in our eyes as lawyers, that the accused physician has a clean presentation in transcripts and in those physician interviews of their thought process and the facts in the patient case. We take this very seriously. Sometimes following the explanation by the physician at this important interview, investigations are closed based on the medical consultant's review. And that can only be achieved if we have a very clear explanation that is thoughtful and that allows the physician to explain his state of mind at the time the patient care was rendered. At the same time, vertical enforcement has increased the quality of evidence needed to allow legal staff to identify whether or not the AG can meet our filing standards, which are based both on prosecutorial ethics and the burden of proof, which is clear and convincing to a reasonable certainty, which is second only to the criminal burden of proof of beyond a reasonable doubt. Your filing standards and our burden of proof is one of the highest in the entire country for medical board licensees. The quality of the evidence is not only scrutinized by the accused physician and their legal representative, but also the administrative law judge who review your cases for you at settlement and at hearing. And that same evidence that's collected during investigations is obviously perused very, very closely by opposing experts at hearing, and often by Superior Court judges on judicial review, appellate court judges on appellate review, and where applicable, the Supreme Court. Our talented Attorney General staff are sometimes outnumbered by multiple opposing counsel with more resources and oftentimes multiple handsomely paid defense experts, sometimes one per patient or subject if that is what the ALJ feels justice requires for this physician who's defending his or her livelihood. Yet the quality of the obtained evidence and the opinion of our retained experts is what wins cases. The collection of evidence at the investigatory phase is what achieves discipline, and it all begins in the vertically enforced investigation. But that same evidence evolves at the litigation phase, which is where it's really put to its use. So the investigations are not an end to themselves. Investigations are bigger than the tasks performed by investigators. Each case involves a patient and the care provided to them, and it obviously involves the investigated physician. And it involves, most importantly, protecting future patients. DCA and their investigators only see the tip of the iceberg when they deliver a completed investigation to our office. The bulk of our legal work on your behalf occurs on filed administrative cases. Our DAGs live with the file case long after the investigation is accepted for prosecution and filing by my office. We take very, very seriously what we affix you, our client's name to, and what we present underneath Kamala Harris's name, the Attorney General. We live with these file cases until it is settled, defaulted, or heard by a judge, and we come here before you every quarter to explain our stipulation recommendations and appear at non-adoptions of proposed orders by ALJs. Our DAGs put their heart and soul, long hours of personal sacrifice to themselves and their families into every single case, as it represents in our eyes a physician to be revoked or remediated as dictated by the patient care or conduct at issue, care that did not meet your high standards. We know that the vertical enforcement program has resulted in stronger disciplinary outcomes, especially in the identification of physicians exposing a danger to patients meriting an interim suspension order action, and including actions against physicians with mental or physical impairment, and in other public safety cases. At the same time, our legal involvement reduces cases against physicians who should not be prosecuted. And we feel that this is important. Physicians are part of the public too. HQE and my staff knows and appreciates that the vertical enforcement program exists solely to protect the public. It does not exist for any other reason. The deputies that work in HQE have weathered all of the challenges presented in the past 11 years by never losing sight of what the law intends. Our DAGs are extremely hardworking in an office where all of our deputies get paid exactly the same amount of money. Yet the DAGs in the other section, the deputies in other sections in our office may not have as much legal work and may not have the same types of challenges that our health quality enforcement deputies have. Our deputies stay in the health quality enforcement section because they believe in the important mission to protect patients and to enforce the health quality in California. It's in our name, even if it means more work for the same pay. We have staff as well that took very hefty pay cuts to work here in HQE, and they come from the finest law firms and prosecutorial agencies all around the country. And I'm very privileged to lead such fine prosecutors. HQE agrees with the mission and intent of the legislation establishing the vertical enforcement program. Notwithstanding the challenges when the program was not really implemented as envisioned and the subsequent fragmentation caused by when the board lost its investigators 3 years ago, our staff has always been very passionate about the vertical enforcement program and the protection it affords the public by involving the lawyers to ensure the quality of the evidence that is produced in these investigations, because it is evidence that ultimately may be used in disciplinary prosecutions of physicians. The vast majority of our staff worked on your cases before vertical enforcement was implemented, including me. The prior model of lawyers and investigators working in silos did not work for this type of important work. I recall handling file cases resulting in de minimis discipline years after investigations were open due to the state of the collected evidence. And I feel we do a really good job identifying those cases very early on and dismissing them as appropriate and resolving them and allowing us to focus on very, very strong cases. With the Complaint Investigation Office in Ms. Kirchmeyer's headquarters, keeping about 300 investigations, which is the lowest level of complexity of cases a year, these investigations that the Complaint Investigation Office handles have been the types of cases that we agree are not going to benefit as much from the vertical enforcement program. They can include conviction cases, petitions to revoke probation, and things like that. We have been left in HQIU with the cases that should be vertically enforced because of the matters that are being brought by the patient and the severity of whatever the care presents. With HQIU also shedding 2 of my clients, we represent the Board of Psychology and also the Osteopathic Medical Board. They're shedding their clients and sending them to the other side of the shop. We hope to see investigations moving forward. We have started working on a subject interview training for investigators, and we have also offered to take some of the burden of scheduling physician interviews from HQIU. We could use our senior legal analysts, who are like paralegals, to do that. So then that way investigators, rather than chasing people down on the phone, they can focus on investigations and their important work. As required by the protocol, we do our part in HQE in identifying cases that don't need a DAG appearance at the physician interview. As investigators remain in HQIU and as they develop that skill, many times we're able to just send the questions to a talented investigator who's well-trained with areas to probe, and it doesn't require the DAG to show up at the subject interview. But throughout, we're directing your investigations.
Thank you. Dr. Kraus?
Thank you, Ms. Castro. Thank you. I must say, in the few short years I've been on the board, that I'm impressed not only with the skill and the compulsive nature of the Deputy Attorney Generals, but indeed with their passion. And it's nice to know that they care about the good work that they're doing. I'm also pleased to hear that you're working with HQIU to try to share some of the burden and help reduce the backlog. Are you hindered at any time by lack of adequate medical experts? Are we working hard enough to keep a large enough panel of medical experts, or does that sometimes really hinder bringing a case forward?
We have the most difficulty, Dr. Kraus, on very obscure areas like pathology or dermatology. So if we could enlist your help in finding those subspecialties within subspecialties, that's where we find the most challenge. Obviously, we are allowed to go off the script and pay a little bit more, but that is rare and far between. And the last time I saw that happen was about 5 years ago. We really couldn't find anyone on our list because there was no one there. Beyond that, what would be good, obviously, in my opinion, would be to pay the experts a little bit more by the hour. It would also be very useful for our staff, who sometimes is at the mercy of the Office of Administrative Hearings calendar and them listening to the entreaties of opposing counsel and respondent requesting last-minute continuances of hearings, that we be able to compensate experts who have cleared their calendars. It is very, very troubling to me that when we know we're going to go to hearing, that if we don't go, we can't pay the expert for the whole day that they cleared their surgery calendar. It's never going to put them in their rightful place, but it would be a good start to be able to say, if OAH grants a continuance within 5 days of when the hearing was going to start and the expert has requested, that we compensate them just on an hourly basis for the last-minute cancellation. And it's important because these are the same experts we're trying to convince to do the right thing. We have to do the right thing by them. And so if we could work with Ms. Kirchmeier on allowing the medical board to, it's just frustrating. Because here's the thing, when we set a hearing with OAH, it's usually at least about 180 days before we're going to go. We always ask the expert, hey, are you available this day? We may not go, we may settle, but I need you. And we work around the expert schedule. Obviously, though, Office of Administrative Hearings will continue hearings as necessary. You know, people get sick, experts aren't available for whatever reason. But if you're canceling a hearing on a Friday, it's not a call you want to make to tell the expert, hey, you know what, you could work on Monday. If they're a surgeon, they're not working Monday. And it's not about the money, it's just about the respect. So that's a challenge that I'm happy to bring to you to fix, Dr. Krause
Great.
and Dr. Yip.
Thank you.
Do you stay close in touch with Ms. Delp regarding areas where the expert coverage may be thin?
With Ms. Delp?
Um,
Probably not with Ms. Delp. I know that we have very close relationships with Ms. Getzinger, and we have been working a lot harder on trying to give Ms. Delp back some of our completed questionnaires on experts and, you know, how they presented at hearing, any feedback that we can give to the expert. We always send the experts the decisions and orders once we're done, because we believe it's very important to make them partners in the result, whether it's good or bad. I think it's always useful for experts to know how their opinion was perceived, how they came across, whether or not they were credible, and hopefully they'll want to do it again. It's a service-oriented interaction with our experts who we cannot do anything without.
Yeah, the feedback is important, both positive and negative, because an expert that's not doing his or her job properly can really hinder, the case going forward.
That's right. And with Ms. Delp's help, I did find out that my staff was not taking that feedback as seriously as they should have at the tail end. They were maybe communicating it amongst ourselves, but we weren't telling the client, hey, this is someone who did a fine job or was very helpful or, yeah.
Thank you.
Thank you, sir.
Thank you. Any comment? No. Actually, I think, Ms. Castro, just to reiterate, we all appreciate your effort and passion. But as you say, sometimes actually it's not the money that counts for the expert review, it's the respect.
Yes.
And when I approach the USC Dean's office, they're actually very excited about helping out.
Mm-hmm.
They say we can send out email, we can invite the special faculty that we want. I think sometimes you have problem getting expert, you may go through that channel and get someone that you really need. So thank you.
Right. It's always useful to involve the experts that have had a very positive experience back in to try and convince others to do it. They're not going to do it for the money. They're going to do it for the good of the profession and for the public.
Any comments from those in the audience? Comments from those on the phone?
Do we have any comments on the line?
And for questions, please press star one.
No?
Not at this time.
We
Right.
have no comments.
Thanks.
Right, thank
So-
you.
Thank you, Ms. Castro. We move on, agenda item 9, Ms. Delp and Ms. Houston will provide a presentation on the probation unit timeframes and action for violations of probation.
So before we get started, I just want to introduce Susan Houston. She's the new enforcement program manager that was hired by the board back in March, and she is over not only probation, but also the CIO and the discipline coordination units. I guess we'll just put it right there. Okay, so as you can see, we have a rather lengthy presentation. So hopefully we'll get through this. So the overview of the presentation is to go over the conditions that are in the manual model of disciplinary terms and conditions, the uniform standards of substance abusing licensee conditions, and what actions staff will take when there's a violation that occurs, and the timeframes to take those actions. Also, at the end of the presentation is some statistics about the probation unit. So the objective is to bring awareness of what actions are taken when a violation occurs, and then also the timeframes for those actions. And just to start with some statutory authorities, just to reiterate, public protection is paramount, and it is also the statutory authority that authorizes the board and the administrative law judges when exercising disciplinary authority is Business and Professions Code, Section 2229. When exercising this discipline authority, action should be aiding in rehabilitating the licensee or restrict the scope of practice or other restrictions as indicated by the evidence presented. The California legislature also set forth that the board shall seek out licensees who have demonstrated deficiencies in competency and then take actions as indicated to include further education, restrictions from practice, or other means that will remove those deficiencies. And a way to carry out those is by putting a physician respondent on probation. So to implement the mandates of Business and Professions Code Section 2229 and the California Code of Regulations Sections 1361 and 1361.5, which are the manual model of disciplinary guidelines and uniform standards, these guidelines are used to create the provisions that are then drafted to create the disciplinary order, which in turn becomes the responsibility of probation staff to ensure through monitoring that the physician respondent is in compliance with the terms and conditions of the order. So we're going to start with the manual model of disciplinary guidelines, and it's important to stress that these are guidelines that, depending on the circumstances, mitigating factors of the violation, you know, not everything that we go over today is set in stone. They are guidelines. So the manual model of disciplinary guidelines, these conditions, as you know, can be deviated from. These guidelines are in the process of being modified. I think later on in the board meeting, we're going through a modification regulation process, and I guess we expect those new modifications to be coming out sometime in August, hopefully September. Some examples of those changes is that some of the guidelines, a probationer would no longer be able to retake the special purpose exam after failing it the first time. And then also out-of-state probationers will now be subjected to taking biological fluid testing. So today's presentation speaks to what is currently in existence of those guidelines. So the first optional condition that can be used is suspension, which is obviously a physician is barred from practicing medicine. So and a suspension could be example for 30 days, 60 days, however, a suspension cannot exceed 1 year. The suspension begins the 16th day after the effective date of a decision. And during suspension, probationer is still required to complete any courses, register for biological fluid, and comply with the standard terms and conditions. So what probation staff does to ensure the suspension is being complied with is that they would drive by or call the place of employment. If the suspension is over 30 days, they will retrieve the wall certificate and the pocket license, and they'll even contact the Drug Enforcement Agency to let them know that they are barred from practicing medicine. If there is a violation for a suspension practicing without a license, within 24 to 48 hours, a referral is made to the investigation office, or the field office. We make a referral to the sworn investigators to further investigate the allegation of practicing medicine with a suspended license. And depending on the findings of that investigation, then an accusation petition to revoke is transmitted to the Attorney General's office. And of course, that investigation timeframe varies. For controlled substances and the disciplinary guidelines, what speaks to related to control is conditions number 5 through 8. And that is where the licensee is prohibited from or limited from ordering, prescribing, administering, furnishing, or possessing a controlled substance. So for a total restriction, it's obvious that they cannot prescribe or do anything at all. And with that, also the surrender of a DA permit goes hand in hand. And they cannot practice medicine sometimes until proof is provided that the permit is surrendered and the prescription pads have also been surrendered. Partial restriction is where the probationer is limited in the types of drugs that he or she can order, prescribe, or dispense. And when that that happens, then DEA is also notified, and the petitioner may ask for his or her DA permit to be reissued, where it just specifies what restrictions that they have. Condition number 8, maintain records, also goes hand in hand with the partial restriction. And condition number 8 of maintaining records, the probationer is required to record a log of all scheduled drugs ordered, prescribed. The log must be available for inspection, copying at all times during the length of probation, and the log must record the name and address of a patient, the date of the doctor's visit, the type and quantity of the drug involved, indications and diagnosis for which drug was furnished. So what staff does to monitor this condition is they will verify with the DA that the permit and or the prescription pads were surrendered. They notify the Drug Enforcement Agency of the drug limitations that they can only prescribe. They obtain proof from the probationer of their surrendered or reissued permit. They will run a cures report, and they also compare the cures report to the logs for compliance and see if there's any discrepancies. So when there's a violation of any of these conditions, say for ordering, dispensing drugs that they shouldn't be doing, within 24 to 48 hours, a referral again is made to the field office. They make a referral to the sworn investigators to investigate. Our sworn investigators are the only ones that have the authority to get certified copies of prescriptions, and this evidence is quite crucial to be able to provide to the Attorney General's office to take disciplinary action. And again, depending on the findings of the investigation, an accusation and petition to revoke is transmitted to the Attorney General's office, and again, those investigation times will vary. If the violation is the probationer does not provide proof of the surrender or reissuance of a permit, within a 3 to 5 business day time frame, staff will generate a noncompliance report, then also send a noncompliance letter to the probationer and asking them to comply within 5 days. And if they don't comply within 5 days, then a citation order with a citation and fine with an order of abatement would be issued. Okay. If there's a violation for not having the log that contains all the elements per the order, it doesn't meet the criteria, again, within 3 business days, staff will document in a noncompliance report, issue a noncompliance letter to the probationer, ask them to come in compliance within 5 days, and if they don't, another citation with an order of abatement would be issued. If there's a discrepancy between the logs and a cures report, depending on the findings of that discrepancy. Staff would, within 7 business days, they get an explanation from the probationer. They would contact the pharmacies to see if they can get confirmation if there was a potential violation. They would also then, if they couldn't get any information from the pharmacy, like I said earlier, they make a referral to the field office to assess because they're the only ones that get certified copies of prescriptions. And then depending on the findings of that investigation, then they would make a referral, a transmittal to the Attorney General's office for an accusation petition to revoke. Conditions 9 and 10, which are abstain from use of alcohol and drugs. The probationers just refrain from use of possession of controlled drugs, dangerous drugs, or drugs that require a prescription, and they are to refrain from use of products or beverages containing alcohol. When there's an abstain for drugs or alcohol, that also goes hand in hand with the biological fluid testing requirement. And these restrictions would not apply to medication that's lawfully prescribed to probationers by another practitioner for a bona fide illness. So within 15 days of receiving any lawfully prescribed medication, the probationer is to notify the board. And the notification must include the issuing practitioner's name, address and telephone number, medication name, strength and quantity, issuing pharmacy name, address and telephone number. So a probationer cannot test positive for any substance to include legally prescribed medication if they did not notify the board. So what staff does to ensure compliance with this condition is that they oversee, make sure they get the list of lawfully prescribed medications from the probationer, and they monitor the biological fluid testing that is conducted by the probationer and our laboratories. If there is a violation of a confirmed positive biological fluid test for drugs or alcohol, within 24 to 48 hours, staff will get an explanation from the probationer and starts to get explanation from the laboratory. And they'll start to obtain certified records from the laboratory. They'll complete a noncompliance report, and they would issue a cease practice order, and a transmittal would be sent to the Attorney General's office for a petition to revoke. We get an explanation from the probationer because we feel it's important. There could be, perhaps, I think it's the last presentation when I did in January, say they got hurt and they did get a lawfully prescribed medication. They have 15 days to report that. So technically, if it shows up as positive, it really may not be a positive because they had 15 days to report a new prescribed medication. So there has to be some research that needs to be conducted. And then when a cease practice order is issued, the probationer cannot resume the practice of medicine until a final decision or an accusation or petition to revoke is rendered. The accusation, petition to revoke must be filed within 15 days after the cease practice order, and if a hearing is requested, then it must take place within 30 days unless the probationer requests a hearing at a later date. Okay, excuse me. So when there's a violation where they do not provide timely notification of a lawfully prescribed medication and there are positive tests, within 24 to 40 hours, we obtain the explanation, we issue the cease practice order. If it's determined that they lawfully were prescribed but they failed to report it, we would lift the cease practice order and issue a citation and fine. But if it was unlawful, then we would transmit to the Attorney General's office for an accusation petition to revoke. So for biological fluid testing, which is condition option number 11, probationers must submit to random, unannounced, observed biological fluid testing. Probationer needs to enter into contract with the lab. We can test for urine, blood, hair, or by breathalyzer. Probationers must be call-in between the hours of midnight and 5 p.m. They're required to call in daily to see if they are required to test, and when called to test, they must test that day, and all testing is at the probationer's expense. So probation staff, what they do to monitor this is they check the approved laboratories database to confirm that they are compliant with calling in daily. And they receive alerts about positive tests. And then they get confirmation also from missed tests from the laboratories. So if the violation, the probationer does not call in daily within 24 to 48 hours, we will request an explanation from the probationer. Again, we look at what the reasons are. If perhaps there was a family illness or if they were ill, depending on the circumstances, we may not consider it to be a violation. But if it's not a plausible reason, within 3 to 5 business days, we would do a noncompliance report. And on the first offense of not calling in, they would get a noncompliance letter alerting them that the second time they would get a citation and fine. If the second offense occurs for not calling in, then we would issue the citation and fine with an order of abatement to continue to comply. And if there's a third offense, we could prepare a transmittal to the Attorney General's office for a petition to revoke for noncompliance. If there's a violation for not testing when requested, again, we ask for an explanation from the probationer within 24 to 48 hours. And then within 3 to 5 days, we would issue a noncompliance report. And on the first offense, we would issue a citation and fine. Second offense, we would issue a cease practice order and transmit to the Attorney General's office for petition to revoke. We need to demonstrate the progressive discipline and a pattern of failing to cooperate with the testing. And then if alcohol is the drug of choice, we might schedule a second test to go in and get a blood test. And if drugs have been an issue, we could schedule a hair test immediately after that.
We're going to go on to required courses. These are going to be options 13 to 17. It's the continued medical education, prescribing practices, medical record keeping, professionalism program ethics, professional boundaries program. So they must enroll within 60 days of the effective date of the order, successfully complete it no later than 6 months of enrollment. They must provide proof of completion no later than 15 days after completing the program. For the medical education courses, they must take a minimum of 65 credits each year. Breakdown is 40 credits satisfies this condition, and the remaining 25 satisfies a license renewal requirement. The prescribing practices and medical record-keeping courses, if required to take other components, have up to 1 year to complete. Ethics course, after completion within 6 months, does have a mandatory 1-year follow-up. Only the professional boundaries course has condition precedent options, such as can't practice medicine until proof of completion, or if fails the program, the board can issue a cease practice order. So violation, if they don't enroll within 60 days, within 3 to 5 business days, we're going to request an explanation from the probationer. We're going to issue a noncompliance report and a noncompliance letter, and we'll give them 7 business days to comply. Again, there could be extenuating circumstances that may grant an extension, for example, a death in the family, an illness, or a family emergency. If they're not complying, we're going to issue a cite and fine with an order of abatement. And again, if they still fail within 7 days of notification, we're going to do noncompliance and transmit the PTR to comply with order of abatement to enroll, or probably refer to AGO for PTR. Okay, for violation, if they enroll but don't comply within the time frame, or does not complete other components within the time frame, or untimely submission of proof of completion, again, within 3 to 5 business days, we're going to ask for an explanation. We're going to do a noncompliance report. Again, if they don't comply, we're going to issue cite and fine with order of abatement, or if still noncompliance, we'll transmit to the field for a PTR. Again, there could be extenuating circumstances, for example, an illness, family illness, death in the family, etc. Like probation enrolls but doesn't complete the course and or components within the time frame, we can issue, like again, the cite and fine, order of abatement. And after noncompliance for an unacceptable explanation, if they don't comply, we're going to transmit to the AGO for PTR. or if they don't provide proof of completion timely, probation will send a non-compliance letter with 7 days to submit proof. And if they don't comply, again, cite and fine, order of abatement. Non-compliance with order of abatement, we're going to transmit to the AGO for a PTR. So violation, if they don't complete the boundaries course within the 6 months with condition precedent, we're going to, within 24 to 48 hours, we're going to ask for an explanation. And again, we'll issue a cease practice order, and that cease practice order will remain in effect until the course is completed. Clinical training program, option 18. Enroll into a clinical training or educational program that assesses the probationer's physical and mental health, basic clinical and communication skills, medical knowledge. They must enroll within 60 days of the effective date of the order. They must successfully complete it no later than 6 months, and they must comply with the program recommendations. Some optional language: if they fail to enroll, participate in, or successfully complete within the timeframes, the board may issue a cease practice order, and they cannot practice until the enrollment or participation is completed. Number 2, if they didn't successfully complete and cannot practice until final decision rendered on the accusation in PTR. 3, within 60 days of successful completion, they must participate in a professional enhancement program. This program conducts quarterly chart reviews, semi-annual practice assessment, and review of personal growth and development. Or a condition precedent option, it'll say probationer cannot practice until they complete the clinical training program. So my staff will contact the provider to confirm enrollment and participation, and they're going to review the program's reports. For example, the neuropsychological exam, staff will set this examination up, and the staff will ensure compliance with all recommendations. So the violation, so the probationer fails to enroll within 60 days, or participates or completes the program within 6 months, or does not comply with program recommendations, within 3 to 5 business days, we're going to ask for an explanation. We're going to confirm the noncompliance with the provider, issue a noncompliance report, and issue a cease practice order. Again, we'll take in any extenuating circumstances that could grant an extension. Again, if we do a cease practice order, it will remain in effect until the probationer enrolls or participates in the program. If they don't comply, again, it'll be a cite and fine with order of abatement, and then we'll transmit it to the AGO for a PTR. If the probationer fails the clinical training program within 24 to 48 hours, we're going to issue a noncompliance report, issue a cease practice order, and transmit to the AGO for a PTR. Again, the probationer should not resume practice of medicine until a final decision has been rendered on the accusation in PTR. Psychiatric evaluation, option 20. They must undergo psychiatric evaluation and psychological testing if deemed necessary. Within 30 days, they must complete the psychological evaluation and psychological testing if deemed necessary by the board-appointed board-certified psychiatrist. They may be required to take further evaluations on whatever periodic basis thereafter as required by the board. Psychiatric evaluations completed prior to the effective date of the decision are not accepted. The cost of the evaluation is covered by the probationer, and the probationer must comply with all restrictions and conditions recommended by the psychiatrist within 15 calendar days of notification by board or designee. There's a condition precedent: they cannot practice medicine until notified by the board that he or she is mentally fit to practice medicine safely. My probation staff will select the board-appointed, board-certified psychiatrist, review the report, and if condition precedent, notify the probationer if he or she is safe to practice medicine. Violation, again, if they don't undergo evaluation within 30 days and they don't comply with recommended restrictions or conditions, Within 3 to 5 business days, we're going to ask the probationer for an explanation. Again, extenuating circumstances could grant an extension. We're going to do a non-compliance report. And again, if they still don't comply, we're going to issue a cite and fine with order of abatement. And if still non-compliance, we're going to transmit to the AGO for a PTR. Psychotherapy, option 21. Within 60 days, they submit to the board the name and qualification of a board-certified psychiatrist or licensed psychologist. Upon approval, they shall undergo and continue psychotherapy treatment. Again, the probationer pays all costs for the treatment. My probation staff will review the qualifications. They'll approve the candidate. They'll ensure the therapist is submitting the quarterly reports. They're going to review those reports and make sure there's any evaluations or recommendations that the probationer is required to submit to. The violation, if they don't submit their therapist's name for approval to undergo therapy within 60 days, within 3 to 5 days, we're going to ask for an explanation. We're going to issue a non-compliance report. Again, after 7 business days, we're going to do non-compliance letter. We're going to issue a cite and fine with order of abatement, or for again, non-compliance, we'll transmit to the field for a PTR. Option 22, medical evaluation and treatment. They have to undergo medical evaluation within 30 calendar days, an evaluation by the board-appointed physician. Following the evaluation, they must comply with all the restrictions within 15 calendar days after notification by the board. If required to undergo medical treatment, probationer shall, within 30 days of notification, submit the name of the treating physician to the board for approval. Once treating physician is approved, they have 15 days to undergo the treatment. Again, the probationer will pay all costs for the medical evaluations and treatment. My probation staff will select the board-appointed physician. They're going to review the reports. They'll approve treating physician of respondent's choice if recommended. They're going to ensure that that physician we receive quarterly reports submitted by them. We're going to request treatment records when necessary, and if there's a condition precedent, we'll notify the probationer if he or she is safe to practice medicine. For the violation, if they do not have the evaluation within 30 days, within 3 to 5 business days, we're going to request an explanation. We're going to do a non-compliance report. And again, we're going to do a non-compliance letter within 7 business days to get them to comply. If they still don't, we're going to issue a cite and fine with an order of abatement, and then we can issue a non-compliance letter and transmit to the AGO for a PTR. For medical evaluation and treatment option 22, if they don't comply with restrictions and conditions within 15 calendar days of being noticed, or they don't submit for approval the name of the treating physician within 30 calendar days of being noticed, within 3 to 5 business days, again, we'll request an explanation, issue the non-compliance report, non-compliance letter, 7 business days to comply. We can issue a cite and fine with order of abatement, and again, refer to the field and do enough for non-compliance. Or the other violation, if the treating physician does not provide quarterly reports to the board, within 3 to 5 business days, we're going to request an explanation. We will do a non-compliance report and do a non-compliance letter and give the probationer 7 business days to comply. And then if they still don't, we can do a cite and fine or non-compliance letter and submit to the field. For monitor, practice billing, independent individual monitors the probationer's medical or billing practices. My staff will approve the monitor of the respondent's choice. They'll ensure quarterly reports are submitted by the monitor and review those reports. For the violation, if they don't submit for approval the name of the monitor within 30 calendar days, or no approved monitor in place within 60 days, They have 5 days to submit the name of a replacement monitor. They have 15 days from the day the new monitor must assume responsibility of monitoring the duties. If they fail to do these within 60 days of the monitor resigning or no longer available. Excuse me. So within 3 to 5 business days, we can do it if they, within 3 to 5 business days, we can do a non-compliance report, a non-compliance letter. They'll give them 7 days to comply. So if they fail to provide the name within 7 days, rather than issue a cite and fine, we'll wait 60 days and issue a cease practice order.
On that one, well, I just want to clarify, that one is they have 30 days to provide the name and get in compliance, and then after 60 days, if they don't, then that's when the cease practice order would take effect.
Thank you. So option 24, solo practice prohibition. Probationer cannot engage in solo practice of medicine. So my staff will approve the office setting. They'll visit the office setting to confirm physician colleague is present. Regular communication with the colleague at the practice setting. The violation within 60 days does not secure employment in appropriate practice setting upon effective date of order, and when practice setting changes, within 24 to 48 hours, we'll do a noncompliance report and we'll issue a cease practice order, and that cease practice order will remain in effect until the appropriate setting is established. Option 25, third-party chaperone. Chaperone present while consulting, examining, or treating patients. My probation staff will approve the names of the chaperone. They're going to review the log or written notifications, and they're going to contact patients on the log to ensure the chaperone is present during visits. The violation, within 60 days, they don't secure an approved chaperone upon the effective date of order, or if chaperone resigns or is no longer available, within 24 to 48 hours, we're going to issue a cease practice order, and that order will be in effect until a chaperone is approved. Violation, if they fail to maintain an appropriate log within 3 to 5 business days, we're going to ask for an explanation, do a noncompliance report. We can issue a cite and fine with order of abatement, and noncompliance to the AGO for PTR. So these logs must contain the patient initials, address and telephone number, medical record number, and date of service. Prohibited practice, option 26. Guideline states verbal notification is required. However, guidelines can be deviated and order can require written notifications or above. So the prohibited practice from performing or treating a specific procedure, surgery, or prohibition on specific patient population. My staff will ensure their logs are completed. They'll contact the patients on the log to ensure the probationer is providing notification of prohibited practice to patients. For the violation, if they fail to provide notification to patients or maintain adequate logs, within 3 to 5 business days, we're going to ask for an explanation. We're going to issue a non-compliance report. We can issue cite and fine with order of abatement, and still non-compliance, we're going to transmit to the field for a PTR.
So that's kind of just giving you an overview of the manual model of disciplinary guidelines, the optional conditions. There are also the standard conditions, and these standard conditions are always within the disciplinary orders. Some of the standard conditions are notification, supervision of physician assistants, general probation requirements, quarterly declarations, as you can see. For the general requirements, they have to keep the board informed of their address change, business or residence change, email or phone number. They must maintain a current and renewed California physician surgeon license. Inform staff when their travel exceeds 30 days. Inform of residence or practice change in another state if it exceeds 30 days. Non-practice condition is within 15 days. They must notify us in writing if their non-practice exceeds 30 calendar days. And within 15 days, they have to notify us when they do return to practice. And periods of non-practice typically do not exceed 2 years. So to monitor the standard conditions, they just ensure that within the order, they're set timeframes, and they just continue to comply with those. But one of the critical ones I point out is that if a probationer does not practice medicine and it's exceeding up to 18 months, and they have to take a clinical training program, they will go ahead and submit to the Attorney General's office a petition to revoke if they haven't proceeded to take that. So they will do their noncompliance report, and depending on what the condition, the standard condition that's violated, they might issue a citation and fine, or again, like I said, issue a transmittal to the Attorney General's office to revoke probation. Getting into the uniform standards for substance abusing licensees, we're starting to see more orders that contain that language. And as you're aware, that these standards cannot be deviated from when there is determined that an individual is deemed to be a substance abusing licensee. So some of the conditions within this disciplinary guideline are the clinical diagnostic evaluation and reports. A board certified physician surgeon needs to conduct a clinical diagnostic evaluation of the probationer, recommend treatment, and recommend any restrictions or compliance that they need to also abide by. They need to notify the board within 24 hours if they feel that the person is unsafe. And the probationer needs to have at least 30 days of negative biological fluid testing while they're going through the clinical diagnostic evaluation. The notice of employer or supervisor, probationer shall provide the board with information regarding all employees and supervisors to whom that they work with, and written consent to the board for those names. And we are able to communicate with those individuals about the probationer's work status, performance, and monitoring. For biological fluid testing, we can order, it's the random testing that includes weekends and holidays that the probationer must take. And the frequency under this guidelines is within the first year, they can take 52 up to 104 tests. And then the second year, we can lower the frequency down to 36 to 104 tests a year, and that can remain for the life of the term of the probation. The support group meetings, within 30 calendar days, they submit the name for approval of their substance abuse support group, and they must attend this support group for the duration of probation. They must attend a minimum of once per week, and they pay all the cost. Worksite monitor, within 30 calendar days, they must submit a name of approval of a monitor. Respondent pays all costs for the monitoring. They have 5 days to submit the name of the monitor, and then 15 days after, they must assume monitoring responsibility. And they also have within 60 days, they must comply with this condition. So with the substance abusing licensees, disciplinary orders, they state in their minor and major violations. So a major violation, as you can see from the slide, I'm going to speed things up, I'm not going to read them all, but if they fail to undergo clinical diagnostic evaluation, they engage in a drug or alcohol-related act related to, while they're practicing, or fail to undergo biological fluid testing, what staff will do within 24 to 40 hours, complete their noncompliance report, and they have 3 alternatives. We can issue a cease practice order, we can also increase the frequency of their biological fluid testing, or we can make a referral to the Attorney General's office for further disciplinary action, or we can take multiple of these actions. So it could be one or multiple that we can take. For minor violations, if a probationer fails to submit the required documentation timely, fails to contract with a worksite monitor, is impaired, fails to comply with terms and conditions that do not impair public safety. Those are considered minor violations. Within 24 to 40 hours, we will do our noncompliance report, and we have the options of issuing a cease practice order, imposing more practice limitations, increasing supervision, increasing their documentation, to issue a cite and fine, require them to undergo a clinical diagnostic evaluation, or take other action as deemed, as determined. With the substance abusing licensees, one of the difference is that we can impose those restrictions without having to file an accusation to get the discipline. And we've been issuing lately a few cease practice orders under this order and requiring individuals to have to go back to take clinical diagnostic evaluations or have increased their frequency lately because they have been not complying with their testing requirements. And so the last part of the presentation is just to go over some statistics. So as I stated earlier, in fiscal year 14-15, we've issued 9 cease practice orders, but in 15-16, we have increased to 14. And our transmittals to the Attorney General's office have increased from 20 to 36. And accusations that have been filed so far have increased also from 21 to 29. The next slide that you have, just a little bit more of statistics. It's broken down by the case type. I know at the last January meeting, it was requested to see some statistics on the number of physicians on probation and what was the allegations of the case type. So as you can see from there, we've got a total of currently 605 probationers. This data was gathered as of July 13th. So as you know, that number is very fluid. So it's as of that date. So just don't want to, keep reading it because we know we're taking up time. You can see the number there, and unprofessional conduct is pretty high, as well as gross negligence and incompetence for reasons why people are placed on probation. And then also in your attachment, again, data was, board members had asked for some data. There's the number of the physicians on probation, breaking them down to see currently if they're practicing in-state or out-of-state, and the terms of their conditions. Tells you whether an individual is like 3 years probation, the year that the probation was ordered, and the case type again, as to why they were placed on probation. So unless you have any questions, that concludes our presentation.
Dr. Kraus?
Ms. Delp, thank you. You and Ms. Houston did a lot of homework for that, and it's appreciated.
Yeah.
One of the things I reflect upon, and I think we touch on little bits of it every time we have a board meeting, is self-assessment, and by which I mean the board assessing itself in terms of its performance. In medicine, we have morbidity and mortality conference. When something goes bad, you sit down in a group and you analyze it. So I'm wondering if we have mechanisms within our board where if a member of the state of California has an untoward medical event, if we analyze that in some organized fashion to say, how did we miss this? Did a doctor do something wrong that could have been brought to our attention sooner? So in some respect, I guess what I'm asking is, what is our own internal quality assurance program like? Do we have benchmarks for quality indicators? So when we read about the board is supposed to respond within 24 to 48 hours if a probationer fails to do something, do we reflect on our performance in doing that? Are there some times when we fall outside of those parameters? And if we do, have there been any cases of untoward outcomes because we haven't done something properly or in timely fashion? So if they don't already exist, and perhaps they do exist amongst the staff, it'd be useful to develop a list of quality indicators of how are we doing. And by that, I don't mean simply, how many cases are older than 365 days or how many cases are older than 550 days, but also trying to tie those statistics of our own internal performance to whether or not there have been or may be circumstances where the citizens of California may not be as well served as they need to be in terms of our protecting them. And maybe that's too much of a question to answer today. Maybe that should be a subject for our next agenda in terms of looking at our own quality indicators and quality assurance program, informing us as to what it is and maybe if it needs to be improved, working on that together to improve that. But you're certainly welcome to respond at this time.
Okay. I think that's a great way to move in that direction. We have recently with our department, they're called performance measures. So performance measures are being implemented. I believe we started tracking them, but the statistics are not coming out yet. And when a violation is identified, staff is to record that into our system, and it will be able to give us an average time frame of when the violation has been noticed to when it actually gets pursued and actions taken. So we're starting to track those metrics, but definitely can expand beyond that. That's going to be implemented.
Thank you.
I was just going to continue on in that vein. I'm wondering if we could see what those PMs are, what those performance metrics are, because many times it's about the timing, but getting to Dr. Krause's point and our point of the board to protect the public, it would be good. I think we talked about it a little bit, and you allude to it about the triaging again. So we don't take the things that can stick at the bottom and do those because they're easier and faster, right? You've already demonstrated that's not the way you're organized. You're actually taking the things that are at the very top. But what you went through today, those imposed 60 days, someone will do something and they have a 24 to 48 hour. I think that's also instructive to do almost, once you get that data, a root cause as to why these things aren't maybe perhaps moving. So I would really like to see those if we could, those performance metrics, if everyone agrees.
Okay, a few questions also. We see the term psychiatry that we have board approved, board appointed. Do we have a pool of psychiatrists that work constantly with the board, that when the violate physicians who need to be evaluated, we immediately have a pool to go to, or more like they find their own and we check them out and then we approve them?
When our board appointed is we use our experts that we use even on our investigative cases. So our database of experts is we go into there and contact whoever's been approved to be an expert, and they would do the evaluations.
Do we have enough of them? Seems we're short of psychiatrists, right?
I don't know. I think in the board packet has maybe the number of our current experts. So I guess I would say yes and no. I mean, we are going to be beefing up with our recruitment to get more people to participate. I mean, I know Ms. Castro had stressed the concern is compensation, and I know that's something that the board continues to try to work on to get our experts compensated more, because I think that is.
Actually, that's my next question. Has there been any complaint from the licensee that we cannot get an appointment with your appointed psychiatrist, or I guess they would pay for that particular psychiatrist, right?
Actually, the board pays for it up front, and then they
okay.
reimburse the board.
Okay. So we set the fee then.
Yeah, we paid in advance to get them into the evaluation, and they pay the board back.
And the other question about the cease practice order, the different kind of cease practice order for different kind, I guess, how serious the crime or the violation is, that I'm just thinking there's days involved and email to the AG's office and issue a non-compliance report, etc. Is there a mechanism that our probation staff would actually monitor? For example, I mean, like put a sign on the door that your doctor sees practice, you cannot see patient anymore, or how do they transfer the patient care for continuity care for the patient too?
Well, we do, our orders become public, the cease practice orders are public. As far as them having to post that in their office, that's not part of the disciplinary guideline. So whatever they would do in fashion of taking an extended vacation or closing their business down is how they would typically notify patients that they are not practicing. It's not something that probation currently in our disciplinary guidelines is required to get involved in.
And Dr. Yep, I just want to follow up on the question on the experts. So when we use experts for our complaint side, the process, that's where we pay them by hour, and it's our set amount of $150 per hour and $200 for testimony. However, when they're doing these evaluations for individuals who are on probation, it's their standard set rate. So there's no hourly, so it has to be done, and then the individual does pay that full amount. So there's no problem with the expert getting less pay than what they would do under a normal individual coming to them. Does that make sense? Yeah.
Right. Well, I'm certainly pleased to have new energy, new blood coming on board to help us move along the probation. But also personally, I think this is the back end, the front end in the future. I also like to see we have more effort paid to encourage the hospital to bring a more 805 report. I have the feeling that the hospital has not been really doing a lot of public protection by forwarding the 805 report to us. I bring up just because Ms. Castro mentioned earlier too. So, are there any public comments from those in the audience? Dr. Hawkins?
Hold on, we may have too many members in here. We're good? Okay.
Dr. Hawkins?
Thank you. Yeah, Dr. Hawkins, a member of the medical board. So I want to thank staff for putting this together. It was a bit burdensome in detail, but what it does is it gives me, and hopefully it gives everyone who's in the room and reviewing this or hearing this an idea what probation involves. So as organizations and we're part of those organizations, protect the public, are concerned about probation and is it effective, what it involves. It's a very, very important perspective of what probation actually involves. It's pretty complicated with very, very specific time frames and that sort of stuff. So it's very, very valuable. Thank you very much.
Thank you. Any more public comments from those in the audience?
Ask a question.
Please.
I'm Carol Moss, and just speaking on behalf of the public, I was just curious to see all of these new developments. Are they going to be retroactive on existing probationary applicants, or is it just going forward?
Well, if a probationer is currently on probation, all of these guidelines that we just talked about or actions would be in effect for them.
Great.
Yeah.
Thank you.
Thank you. Any comments from those on the phone?
Do we have any comments on the line?
Yes, we do. We turn to the line of Genevieve Clarville. Please go ahead. Your line is open.
Yes, I wanted to know if you know how many people violate their probation. How often does that happen? Or that's very rarely, or are you keeping track of that?
Can you hear?
What's the question, number of people that violated probation?
Yes.
Let me see it. Well, I don't know if I have the exact number because it doesn't include our rotation and fines right now, but cease practice orders, like I said, we've already in 15-16 have issued 14 and transmitted 36 cases. So those would be numbers of people who have violated probation. I don't have the cite and fine statistics with me, and also obviously we've already taken action already in this fiscal year, 16-17, and there's already been a lot of cease practice orders and petitions to revoke that have also been submitted. So I don't fortunately have the exact number.
Oh, well. Any comments from those on the phone?
Any additional comments on the line?
We have no further questions in queue from the phone lines.
Okay, thanks. So move on, agenda item 10. Any members have agenda items for the next enforcement committee meeting? Dr. Kraus?
Yeah, I'd like to see us have staff report and discuss quality indicators and quality assurance program for board performance.
Great. Dr. Bowman?
I concur with Dr. Kraus.
Great, thank you. Are there any public comments from those in the audience on future agenda items? I see none. Are there any comments from those on the phone for future agenda items?
Do we have any comments on the line?
Oh,
Please press star then 1 on the phone if you'd like to queue up for a question or comment.
we do have one.
Thank you.
It's on a non-agenda item.
Is it for the future, though? Is it?
One moment for the comments on the line.
Yeah, this is a non-agenda item.
No, it's for the future agenda item.
I don't know.
Are you saying that you missed,
It's not on a future agenda. I'm not sure if it's a future agenda item.
are you trying to open up agenda item 2, public comments on items not on the agenda?
It was my understanding that there is a time in the board meeting where we can bring forth public comments that are not on the agenda, and it's my understanding that you won't be able to make a comment on them either.
Do you mean to be speaking to the full board? This is the enforcement committee. The full board is going to start.
The full board.
Okay.
That's what I thought I
If
was
you,
waiting for.
in just a few minutes.
Perfect. Okay, that was my understanding. Sorry
Thank you.
about that.
Thank you, thank you. Okay, so the.
There's a comment
the
on,
phone-
do we have any comments on the line? Greg, the comments on the line?
We have no questions in queue.
Okay, great, thank you. Now we move on, agenda item 11, adjournment. So move, and second, okay. Good. Thank you.